Car crash cases, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you. Your tough legal questions answered by our experts. The attorneys with Josh Wright from the law firm of Hollis Wright and host David Lamb.
Good evening and welcome into the attorneys. Thank you so much for joining us tonight. On the show tonight, the way this works for the next half hour, we have a panel of experts assembled to deal with a subject that we think you're going to be interested in, but it's always better if you're a part of the conversation. You can do that by the information you see at the bottom of your screen all throughout the program, ways you can connect with us, get your questions into us. Also, the firm of Hollis Wright, they make available attorneys standing by live right now to speak with you. So while this show is on the air, attorneys are standing by to take your calls, so please take advantage of that opportunity. Leading our conversation, as he often does, managing partner of Hollis Wright, Josh Wright.
How you doing?
I'm good. How about you?
You know, great. I really can't tell you how much I'm enjoying summer and kind of getting things cranked off, and it's been great. It's been a good time of the year to be a lawyer.
And your kids are at an age where it's an active. It's active summer.
Yeah, there's no question about
that.
It's
full on.
100%. All right, so tonight we're going to talk about being active in the summer. Luckily, my kids are not quite old enough for this yet. We're going to be talking about DUI and minors in possession, which is a significant issue that impacts a lot of the viewing audience, especially with all the universities and younger kids that we have out for the summer that can be impacted by this. We've got a first-time guest on the show, and we can't say that every time because a lot of times we have repeat visitors. Woody Ketcham from Ketcham Law locally here. How'd you get into this area of the law?
Well, I went out on my own after about a year of practicing law with a small firm. And I found criminal law to be interesting. I would say I'm a fairly conservative individual. You know, grew up here in Alabama from a big family, grew up in church. But to me, a lawyer was somebody that was in court, that was negotiating, was dealing with DAs or dealing with criminal defense attorneys. So to me, I thought criminal defense would eventually lead me to getting to do what I wanted to do and what I thought being a lawyer really was. So that's kind of how it started out.
Well, we're super excited to have you on the show for the first time, and know you'll do a great job. We're going to be talking, as we mentioned, about DUIs and minors in possession. And I think of an old story when I was a second-year lawyer that's kind of interesting, where I represented a young lady that we had as a family friend who was involved in an event on a boat in Destin for spring break where 73 different girls ended up with a minor in possession charge.
What?
Yep.
I wish I'd have had that case.
I know, and so it's kind of interesting. Ultimately, it was passed off to the right criminal lawyers that were handling it. But so this stuff happens, and it definitely happens during the summer. So let's just talk a little bit about it. I mean, let's before we get into DUI, let's talk a little bit about minor possession because we do see that come up a lot. How does that law kind of work?
Pretty much, I would say it's in place to keep alcohol or punish those who have alcohol, in their possession that are underage. So you're looking at 20-year-olds, 19-year-olds, 18-year-olds. Generally, you're looking at college students is where I think it's most common, and most of the time when somebody is charged with minor in possession, they're also being charged with a DUI or an open container, something that is alcohol related. But it's enacted. It's there to try to deter underage drinking.
I know this is a little off topic, but let's talk about it just for a second. It sounds to me if you're a minor and you have received a possession or an open container, getting a lawyer is important because there probably are some youthful offender options that you've got to be able to protect your record moving forward, because when we're all minors, we don't always make the best decisions. We're going to make some mistakes here and there. Talk just a little bit about that. I mean, youthful offender is an option for people that are of a certain age.
It is. If you're 20 or below, you can request that the court give you youthful offender status. You're not pleading guilty. You're being adjudicated as a youthful offender, and that could cover murder down to public intox. And a lot of attorneys I feel like use youthful offender a little too liberally. A lot of individuals just walk into court and say, "Oh, I want to get youthful offender status," but youthful offender status triggers license suspensions. You do have a youthful offender status adjudication, so I mean it's there. We don't know what it's for, but in my experience, what I tell people is speak with an experienced lawyer, because there are other options sometimes, and sometimes youthful offender isn't even the best option. We can still keep it off your record, and you don't get a license suspension. But yes, youthful offender is definitely something that minors should look at. Anyone that's charged with minor in possession, that's definitely something you don't want on your record, in my opinion. Student going into trying to get jobs, but you're not going to prison. So, it's still something you should speak with a lawyer about.
Yeah, David, we've done a lot of shows on dram shop litigation involving alcohol-related events on the civil side. And as you well know, I do a lot of that law. And a lot of times what we're dealing with is minors that are sold alcohol by convenience stores or bars or restaurants that go out and that are injured, and their parents have claims too. So although there may be a minor in possession criminal component where somebody can be criminally prosecuted, this area of the law also impacts individuals where their children have been injured because someone sold them alcohol, and the parent has a cause of action called the Civil Damages Act against those individuals. So sometimes those things interplay with each other. As often the law does, where you'll have multiple different circumstances.
We love getting questions. Got some good ones. A question we've got here: can I only get a DUI if I have been drinking?
It's a good question.
That is a good question, and unfortunately, I feel like a lot of people are operating off a false assumption that I wasn't drinking, so I can't get a DUI. But it's false. I mean, you can get a DUI for drinking alcohol, for being under the influence of a controlled substance, or both. So it's kind of an and/or when it comes to alcohol and/or drugs.
Am I responsible for those in my car? Like if I'm not drinking, but folks in my car are drinking?
Are you driving?
Yeah, I'm driving.
Well, you're in.
I like how he asked you the question. Hey, typical lawyer right here.
Right.
Are you driving?
Question with a
Please let me
question.
know first.
You are in possession of the vehicle, thus you are under the law generally going to be held accountable for what's in the vehicle, what's within reach. But if it is on a passenger's person, it's in their pocket, usually that's off you and on them. But they can't get a DUI if they're not operating the vehicle, if the vehicle's capable of being operated. But yeah, you could be held responsible if there's an open container. Right. So yeah, you could be looking at getting charged.
Talk for a minute. Are we about to go to break?
Can we go to break?
We come back. I want to talk about what being an actual physical ability to operate the vehicle actually is, because I think people think it means operating the vehicle 100% of the time. That may not always be the case. So we'll talk about that when we come back, because I know Woody will be able to field that question.
And Woody's going to grill me some more.
That's right. I like when he asks that question.
Stay tuned. We're coming back. More of the attorneys as we head to break. A reminder of how you can join the conversation. Love to have you do so. Also follow the firm on social media. Facebook, just search the term Hollis Wright, and on Twitter, it's Hollis_Wright. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys.
Welcome back into the attorneys. Minors, alcohol, and DUI, the topic of conversation tonight. I'm sure that one's going to beg some questions from you. Would love to have you join the conversation. You can do so with the information you see on their screen, or if you would like to speak with an attorney, attorneys from Hollis Wright standing by right now to speak with you. Josh?
You know, it's interesting, that firm fact when we came back in from break, that people that drink alcohol as minors are 7 times more likely to be in an alcohol-related accident. And I know Woody sees this on a daily basis. Remember, one of the statistics we've done from another show, the typical drunk driver, before they have an accident, operates a vehicle 50 times drunk before they ever have an accident.
That's
when you
shocking.
start to think about that, you start to recognize the importance, for example, wearing your seatbelt.
Yeah.
Because you may be doing it right, but somebody else may not be doing it right. So it's something to definitely watch.
I used that
person.
statistic on my kids,
Yeah.
and told them that very fact, that, that you got to watch out.
No
You gotta be
question.
ready.
All right, so when we left, we talked about this issue, and it's a question that I think people need to understand, and that is this. In order to get a DUI in Alabama, do you have to be operating the vehicle, or are there circumstances where you may not be actually operating the vehicle where you could still get a DUI?
Yes, there are circumstances where you could still get a DUI and you're not physically behind the wheel or driving it. The best way I think to explain it is if the car works, if it's operable, if it can run, and you are near the ignition with keys, then if you can turn it and go, they're going to view that you are in control and can operate the vehicle. So if the keys are in ignition or on the floor and you're asleep, you're operating the vehicle as long as it's able to run and it's just not on blocks in your front yard.
Now, have you seen an uptick over the last, decade of non-alcohol but prescription medication driving under the influence claims? Because I have seen it just generally as a lawyer, and I don't know what to equate that to, but I mean, that's something you probably deal with too, isn't
I'm
it?
starting to deal with that a lot more, whether it's just doctors are prescribing individuals at probably a much higher rate, whether it's just that these individuals are hooked on prescription pills. But lots of times it's individuals that have a legitimate prescription. The doctor says, you need to take this, and they don't realize it could make them be under the influence, or they think a doctor's giving it to me, I can drive. And that's not the case. I see a lot. I've got a number of what I call A3 or A5, depending on what the ticket, what the officer alleges. But they're, prescription pills involve DUIs, so it's becoming much more common.
Now, the laws related to DUIs and the penalties, have they gotten stricter since you started practicing law?
They have. They've gotten, I'd say, stricter, but they've also got more complex in ways that allow little loopholes. I've found that there really is never just one certain DUI. It's always a case-by-case scenario. Whether you submitted to a blood test, whether you blew the Draeger or did not, whether they cited you with an A1 or an A5, what road you were on, what court arrested you. So the penalties are stricter, but I find that there's become more and more arguments that can be made on the legal front.
Talk to me about license restrictions and how that works, because I think people assume that if they're stopped for DUI, they can refuse, for example, to do a field sobriety test, refuse when they get to the station to do a blood alcohol test or maybe do the intoxilizer test and say they don't want to do that, but they can continue to drive. The reality is that may not be the case.
Yes, the reality is that very well may not be the case. When you have been arrested for DUI, you may not have your license, but you can drive for 45 days.
Okay.
But then an administrative suspension kicks in. It's 90 days for a first, a year for a second, things of that nature. So you can drive generally for at least 45 days. You need a lawyer to either get that initial administrative suspension thrown out, or we get what's called a stay, so we can keep you driving legally. That's what I tell my clients. I can keep you driving legally. You may never lose your license, but you may, and that's just something we have to address as it comes about.
Explain, if you will, just in general, how does the process from being pulled over to either submitting yourself to a blood test or blowing into an intoxilizer machine at the police station, how does that process happen? Because I know there are some side tests that are used to confirm whether to an officer whether or not somebody may be intoxicated above the legal limit. There's some tests on the side of the road that can assist the officer that may not be admissible. How does that kind of from the stop forward generally work?
Well, the officers have to have what I call a good stop. Generally, it's speeding, improper lane change. You have a bad tag, or a tag light out. But once you're stopped, they do further investigating. They're trying to smell alcohol, look at your eyes. They're trying to determine if you are under the influence. If they determine that they think you are under the influence, they have a probable cause to initiate testing to possibly arrest you. What we call the preliminary breath test, the PBT is the roadside test. It's not admissible in court. You can refuse that and not be in violation of the implied consent rule, which says you have to blow or give blood, but that's at the station. So generally, if the officer says, man, I think this guy's under the influence, I'm arresting him, they bring you back to the station, and that's where they ask you if you want to blow or not into the Draeger. That is where you give your breath test, or if they suspect there's drugs involved and not alcohol, they're gonna ask you for your blood. And if you can refuse that as well, but they'll generally go get a judge in the middle of the night to issue a warrant, and they'll take you to the hospital and pull blood from you so that they can have 6 months to a year later when it comes to prosecuting you.
Is there a right way to do it, a wrong way to do it if you found yourself in that circumstance? I mean, I know that I'm not trying to get you to give away all your secrets, but I mean, is there a general consensus as to whether it's easier to defend a DUI if you haven't taken a blood test, haven't taken the intoxilizer, or provided the blow in the intoxilizer? Is there a general consensus on how that works, or?
It is easier to defend a DUI when somebody has not submitted to a breath test or given a blood sample. The lawyer answer to something like that, though, is it does depend. That's a popular question, and sometimes it's better off if you comply, sometimes it's not, but generally most people refuse.
I think we'll go through some examples when we get back, but I think one of the important things Woody just mentioned is there are circumstances where you know that you are capable of operating a vehicle, you're not intoxicated, and blowing into that machine is going to help you because there are certain presumptions that will be to your advantage. Right. And so I do think it's a case by case, but I wanted to ask him that question. I was trying to figure out what he thought about that because we've had some other folks talking about DUIs. But when we come back, let's kind of unwrap that just a little bit more, and we'll give some advice to people.
That sounds good. We are stepping aside our final break of the evening. Just a few minutes remaining. If you want to join our conversation tonight, there's the information you need to do so. Stay tuned. More of The Attorneys coming right up.
I'm Josh Wright with the law firm of Hollis Wright. Now, serving on a jury can be confusing because there's some information that the attorneys in the case aren't allowed to tell you. And in wrongful death cases, it might surprise you. In tonight's Legal 4-in-1, we're answering the question, what evidence is allowed in a wrongful death case? That's a case where one person's conduct caused the death of another. A wrongful death case is a civil cause of action for someone's death where money damages may be awarded, not jail time. In these cases, a lawyer can only talk about punishing and deterring the defendant for causing the death. That leaves out a lot of information about the person who died, including how that person's death has affected his family and his community. The reason lawyers only talk about punishing and deterring the defendant in these cases is this. In a death case, at the end of the trial, the judge will read a jury charge which says the following. The damages in this case are punitive and not compensatory. Punitive damages are awarded to preserve human life, to punish the defendant for its wrongful conduct, and to deter or discourage the defendant and others from doing the same or similar wrongs in the future. This means that in Alabama, lawyers cannot talk about how great the loss was to a person's family or friends for that death. They can't talk about lost wages or the financial impact on that person's family. Lawyers can't mention how much that person loved his wife, kids or grandkids, or what it would have meant to walk a daughter down the aisle, for example, in her wedding. In short, lawyers cannot talk about all the things that a person who died at the hands of another missed out on in his own life. In Alabama, the legislature said you can't put a value of someone's life. So as lawyers, what we can do, the only thing we can do, is ask that the defendant is deterred and punished for the wrongful conduct that caused the death in the first place. We can ask that the jury send a message, a loud message, to prevent such types of death in the future. For example, if a truck driver caused a crash where someone died, the jury can send a message by making the truck driver pay money damages. The hope is that other drivers will be discouraged from the dangerous conduct that caused the death. As attorneys, we often wish we could submit more evidence to the court about the person who died, but unfortunately, we can't. If you are ever a juror on such a case, please keep in mind what I've told you today about wrongful death cases. Remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. A competent lawyer will respond to every question you send in. That's our pledge and promise to you.
Welcome back into the attorneys, our final segment here. Just a few minutes remaining, about 7 minutes remaining in our program tonight. So if you want to speak with an attorney who's standing by live, you need to take advantage of that opportunity. Josh?
All right, so Woody, when we left, I want to unpackage just a little bit more the concept of there are certain presumptions under our DUI laws that are to the advantage of the person that has had not too many drinks, but has maybe had one drink, where if they blow a certain level, there is a presumption they're not intoxicated, those types of things. Is there not?
There is. I mean, the law is written if you're of age, .08 or above, you're under the influence. But you could be issued for a DUI for blowing a .04 if the officer thinks you're under the influence. But to kind of, I guess, to give you a better answer to your question earlier, I tell people, you know, they ask, should I blow or should I not? And what I tell people is, generally, if you have a clean record and it's around town, it's around where you live, you know a lawyer, say you know me, you're better off blowing or submitting to a test at the station. You're arrested, you're there. If you're not intoxicated, or if you don't feel as if you're really drunk. I tell people, if you're really drunk or you have priors, don't do anything. Yeah. But if you're sober enough in your mind and you have a good record, a good lawyer is going to keep it off your record, and we're not going to have to deal with further license stuff for your refusal. You know, David, it's interesting. You wonder sometimes, because you have probably heard of these people and maybe even have friends that have been through, you know, alcohol abuse. But somebody gets a DUI 1, and then you hear they get a DUI 2, and then they get a DUI 3, and you're like, how can you be so dumb to get yourself in that circumstance? The interesting thing that a lot of people don't know is when the officer walks to your car, he knows your criminal record, or has the ability to know your criminal record based on your license tag and who you are, probably knows exactly who you are and what events you've been through in your life. So that is where people probably compound their mistakes and get themselves in more trouble over and over and over again. If you've got a clean record, you just got to be real careful.
How difficult is it to defend a public intoxication charge?
It's pretty difficult because it's such a vaguely over-encompassing written law. I mean, pretty much if somebody deems you a threat, or if somebody says he's a threat to himself, he's intoxicated, the officer can arrest you. To me, it's kind of a catch-all. I find clients getting arrested for public intox just because. But that doesn't mean we can't fight it. That doesn't mean we can't work out a good deal, keep it off your record, especially if you don't have priors. But you get one, you plead guilty to it, you get another. Eventually, any court's going to go, this guy's a problem. Any employer is going to say, this guy has a problem. So that's why it's important to get representation, get it done right the first time.
He said exactly what I was about to supplement, and that's exactly right. Get a lawyer involved, because employers look at this stuff. I mean, you know, think about this. If you need a tip ball because there are two people that are interviewing for the same spot, and one needs a tip ball to get the job over the other, I'm going to take somebody that doesn't have the priors and doesn't have the public intoxication, which is kind of a, you know, something you don't want to get in life. I'm going to take that and I'm going to use that as a hiring decision a lot of times over somebody that has no criminal record. So getting a lawyer involved is super important to make sure you try and keep that record as clean as you can.
How about fake ID charges? Because that's an area that in the public is almost kind of dealt with flippantly. So how serious are those charges?
I'd say, depending on it, I mean, it's a forged instrument, which is a misdemeanor, and when you see that on paper, you're not usually thinking fake ID. Right. Oh, he was in college, he was down there at T-Town trying to get into a bar. It's a forged instrument, which can be, go up to a felony, up down to a misdemeanor, depending on the severity. But where you find it is usually, I think, in college towns, right. And it's usually somebody trying to purchase alcohol. If you pass it when you're with an officer and trying to claim it as your ID, that's a different type of charge, and that's usually going to be looked at more severely.
Yeah. We have just a couple of minutes remaining. Time just is flying by, but I want to give both of you an opportunity for a final thought. And Woody, if you will, start with you, please. Just something to leave the viewers with tonight.
I think the main thing I would tell anyone that finds himself arrested is reach out to a lawyer. Find somebody you know that you trust who's maybe hired some lawyer if you do not know a criminal defense lawyer personally, and speak with them. Generally, the crime you're being accused of, maybe you did it, maybe you didn't, but you need advice to get through it. And if you have a clean record, you want to keep a clean record. I mean, my clients are you and me type people, or you and me type people's children. I mean, we're talking about good people that have a good job, have a family, have kids, wife, and they need to keep driving, they need to keep their career going forward, or they're in school, and we don't want to deter their career path because of some stupid mistake.
Right.
So what I tell people is take it serious. Yeah, you might not be going to prison, but you may be drastically affecting your future.
Yeah. The one final thing, because I was going to ask Woody, is that it's even more important to get a lawyer in circumstances where on a first offense you blow double the legal limit, because the laws have changed so drastically where if you blow double the legal limit, there are some very significant issues that you can run into, not just with license suspension, but with jail time and fines. The other issue is, if you are a minor, there are options of youthful offender. Getting a lawyer involved, if you're a parent who has a minor that gets in trouble in the summer and does something the wrong way, we understand people are going to make mistakes, but you want to get with a lawyer quickly, because you want an option at least for that lawyer to lead, guide, and direct you through the process, to be able to say, hey, there may be a way that we can plea a youthful offender here where this does not get on this child's record for the poor decision making that they had. So, having guys like Woody around are important to be able to help lead, guide, and direct people through it.
Good show. Appreciate the time.
Thanks for being on, man.
Hey, thank you guys. Enjoyed it.
Thank you so much. And as always, thank you for joining us each and every Sunday evening. We appreciate it. As we wrap things up here, here's how you can get in touch with the firm of Hollis Wright. Again, we appreciate you being with us each and every Sunday night, and we'll see you next time on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.